Welcome to our Profiles in Leadership series. This series offers an unparalleled opportunity to gain insights from top leaders who serve in government, education, the private sector, and civil society. In each episode, we'll invite these leaders to reflect on their journey and share skills, core values, and qualities that made them the leader they are today. I'm very pleased to have Nick Groombridge with us today. Nick is the founding partner of Groombridge, Wu, Lofman, and Stone LLP. Nick is one of the nation's leading trial lawyers, focusing exclusively on intellectual property litigation. Over the past 35 years, Nick has been lead counsel in over 150 patent cases in federal district courts and has tried dozens of bench and jury trials and has successfully argued more than 30 cases in the Court of Appeals for the Federal Circuit. Nick has litigated patents across a wide range of technical areas, including software, semiconductors, pharmaceuticals, biotechnology, wireless networking, consumer electronics, specialty chemicals, automotive parts, financial services, and medical devices. He's a frequent speaker on developments in patent law and has taught courses on patent litigation at both Columbia Law School and NYU School of Law. Clients describe Nick as, quote, an incredibly good trial attorney who takes the time to master every detail of a case and dominates the courtroom with his knowledge of both the law and the facts. Welcome, Nick.
Thank you, Daryl. I'm not sure if I can live up to that introduction, but I will do my best.
Let's start, Nick, with the last part of the introduction where it talks about your experience as a trial lawyer. You had done an earlier interview with Professor Hugh Hansen, and in that you talked about the importance of good storytelling and how it's important to be able to engage with facts which have nothing to do with your life, and to be able to engage a jury that it may not be as sophisticated on the technical side of things with the importance of those facts. Tell us your thought process, your preparation process, how you go about telling that compelling story.
Well, Daryl, my mantra, I think I could say, is I want to know what really happened. And so by way of preparation, what I want to do is dig into the facts and understand the actual series of events that led us to where we are in whatever the dispute may be, and not try to engage in a hunt for what are called good facts or bad facts. That I think many lawyers go through the factual record with that kind of approach, where they're looking for things that either support a predetermined narrative that they want to tell or contradict it. And I have always found that to be not the most effective way to prepare, because ultimately it's better to understand the true history and then build your legal argument on top of that, so that you're not fighting any of the facts, right? As opposed to the situation where all too often we see an approach in which it seems as though both sides are trying to stack up a pile of facts, one good, one bad, with the expectation that whoever has the higher stack at the end will win. And that is part of what I think leads to frustration that we see with juries and indeed with judges, that the lawyers are not really interested in the truth. They're just interested in picking out pieces to construct a version of history that isn't actual history. And, sometimes, it's common to hear lay people say things like lawyers take your words and twist them. And it's that sort of thing that I think is it's unfortunate for the legal system as a whole, and it also, to me, is less effective because you always have to deal with things that are inconvenient and don't fit. And every time I hear lawyers talking about explaining away a bad fact, for example, it really makes me wince in some fashion, because I think it's, it's not what we should be doing. And certainly in my view, it's not the most effective way. So my preparation is really to say, tell me what happened. How did we get here? Right? How did these events unfold? Who were the people involved? What are their personalities? What was going on? And once we've understood that, then we can figure out, okay, from there, what is the legal theory that we need in order to get us to where we want to be.
Do you find it difficult to keep the attention and interest of jurors throughout the trial?
It can be difficult. I mean, I think one of the things that's very important is pace. And I think not dwelling too long on particular subject matter. As lawyers, we tend to have a more is more view, and we always want to explain more. And you see this, for example, in the set of forces that leads courts to set word limits and page limits, because without that, the lawyers will go on and on and on and on and on. And the same is true, I think, in making a verbal presentation to a jury, or indeed, to a judge at times, right? That that we need to understand that we've got to make a point and then move on, right? And not repeat it because we're trying to sort of wring out every last bit of argument and narrative in our support. And that's what loses people, that when I hear about the reaction of juries, what, they need things to keep moving, and they need there to be some level of dynamic exchange in the courtroom in order for their interest to be there. And so I think pace is the principal thing, and resisting the desire to go on too long, which is what I might be doing right now. But I'll just tell you an anecdote that a friend of mine who is a very good trial lawyer in Texas told me once that his rule of thumb was you never cross-examine an opposing expert for more than 45 minutes. Now, I'm not sure that I would live with the 45 minutes, but I think that the sort of teachable moment there is very valid. Of like, you could go for 3 hours, but 3 hours is not better than 45 minutes. It's worse, right? In most situations, and so that's a very good, to me, concrete example of how we keep people's attention.
Thanks, Nick. Lots of good stuff in there. Let's shift gears and talk about your new firm. So you are part of a large firm, full service, big setup, and you decided to venture out on your own with a good group of stalwart companions, almost like Lord of the Ring fashion. It is small, more beautiful.
Well, for us at the moment, it is, and what I would say, so there's no mystery. Most of us came from Paul Weiss, which is a large and very good law firm, and I should say we had a very amicable parting from Paul Weiss, and I continue to have a great many friends there. But what we had decided, I think, was that in this field, it made more sense for us to be an independent practice, and to give us the opportunity to structure the practice and conduct it in ways that are, can be a little bit difficult in the context of, say, 1,000-lawyer firm. And so now we're approximately 25 lawyers. We're fortunate in that we have other people coming to join us, mostly from big law, by the way. But I think so far everyone has been very happy with the new law firm, and with the ability to basically make our own decisions about everything. And if we get them wrong, it's on us, but I would say this has been the most empowering professional move of my life. And I think pretty much all my colleagues feel that way too, right? That here we are, in charge of our own destiny. I don't know if we're like the Fellowship of the Ring, but we're setting out on some kind of adventure for sure.
So, are you still growing?
We are still growing, and I think we will continue to grow. I think we want to, not to manage that process, right? To not grow too rapidly. But yes, very much we are in expansion mode.
So there are two elements there. There's the speed, which you
Yeah.
mentioned, and also the size. So what's a good pace and what's a good size?
I think I wouldn't set a numerical upper limit on size, but at the moment I should know the number, but we're probably 26 or 27 lawyers. If we were 35, that would be fine, right? I think it depends upon having a group of people that enjoy working together and work well together, and that ultimately one wants that to be the kind of watchword, the guiding principle for how big do we get, right? And to have a situation in which the management of the enterprise can be done by consensus, and basically everyone can feel that they have a voice and that they're involved. And to me, that's probably the constraint on size. When you get past a certain point, that becomes, just as a practical matter, very difficult to do.
And you've got two offices right now in New York and in DC.
Yes.
Are you thinking of expanding?
We are, right? So I'm not yet in a position to say where, but we will be. I can confidently predict that our footprint will be expanding. Right?
All this is good news. Now, then, when you think about your day-to-day role, previously you were managing a group of attorneys, but within the context of a large law firm, now you're essentially running your own business. How different is it?
It's a lot more different than I thought it would be. I mean, I have been in two large law firms where I had in both of them some form of management role. And I thought I knew quite a bit about running a law practice and about the business of law. Creating a startup taught me very abruptly that I didn't know nearly as much as I thought I knew. And I have had to learn a great deal, and my colleagues with me. And in a huge law firm, there's always somebody whose job it is to deal with whatever concern you may have, right? In a startup, that's not true. It's on us, right? So if the time management software doesn't work, that's our problem, right? We have to figure it out, right? We have to make sure that when we negotiate for office space, we have to make sure the office space is appropriate and works for everyone. Those kind of things. Managing cash flow, all of these types of things are much more. There's a huge immediacy, which I have to say I have been very much enjoying. I imagine there comes a point at which that novelty wears off, but I think the sense of being responsible for all aspects of one's professional life is a good thing, right? And it's a very, in some way, grounding kind of thing, right? That this only works because we make it work, and we need to know all about it and not be relying on some kind of often unseen infrastructure that handles these things for us. And the ability to do it is one of the things that's empowering. When we walk into the office, look at each other and say, wow, can you believe we actually have this? And it feels great, right? And I never had that feeling before at the other firms I was at.
And you guys are winning awards all over the place, and doing a good job at sharing the good news. So what would you say has been the recipe for your success?
I think it's inclusiveness in large part. I mean, well, at some level, doing good legal work, right? You've got to have clients that want to hire you. We were very fortunate that essentially all of our clients came with us. And we have been fortunate at bringing in actually quite a lot of new work since we founded the firm. But I think the fundamental principle is having people who are highly motivated, and that it's easier to motivate people if you treat them as responsible professional adults. I think one of the problems with large organizations is that you necessarily get a degree of alienation. That one of the things that used to always trouble me was when I would hear partners talking about the law firm as them, not us, right? I would say, we are the law firm, but it's very revealing when people speak that way, right? That they feel in some respects like they're working for the man. And if you're in a small law firm, not even just the partners, but all of my colleagues, I look at as my colleagues and say, I want you to feel like you're part of this, right? If you have a question about it, come and ask me. If you want to know about the finances, I'll tell you, right? If you want to know about the plans for the future, I'll tell you, right? If you have ideas, they're gratefully received. And we're all in this together, and hopefully for the long term. And that is, I think, for at all levels, it's in some ways, it motivates people more. And ultimately, in a personal services business, the quality of the service is very much impacted by the morale of the people who are providing the service. And so I think, deep down, that to me is the single most important factor.
So I noticed that your bio doesn't say Mayor Groombridge or Senior Partner Groombridge or Managing Partner Groombridge. It's partner.
Correct.
And so was that deliberate?
It's absolutely deliberate. And, I think one of the guiding principles of the firm is that is to treat people as peers, not subordinates. So, I'm the most senior because I'm the oldest and I've been doing this the longest, but I'm just one partner amongst the group right now.
So it sounds like you're trying to have a flat hierarchy, as flat as possible.
I think in the context of the law firm, it can't be completely flat. We have essentially three tiers. We have partners, counsel, and associates, but we are much more interested in having those be in kind of reducing the differences between those rather than amplifying them.
Do you get a sense that if an associate has a contrarian view on how to approach a case, that he or she would be comfortable voicing it to, say, the partner in charge?
I think one of the things I strive to do is create an environment in which the answer to that question is yes. And I recognize that it's difficult, that this has always been the case. But for example, often when we're in meetings, I will deliberately try to train myself to speak last, because I know that if I speak first, it will make it more difficult for others to express a view that they might perceive as contrary, right? And and I think it's also reinforcing that when someone contributes an idea, if you accept the idea, that's great. Everything's fine, right? If you reject the idea, then you need to be careful to make sure that the person is not disincentivized from doing so the next time around, right? And so I again would always want to provide some kind of explanation of saying, look, that's great, and I'm very glad you think about this. I think I'd like to go in a different direction, and here's why, right? But I want us to have that dialogue, and I want them to feel like they were heard and taken seriously, right? And and I mean, very often their ideas are followed. We just have had a situation that I can think of where one of the more junior lawyers came up with an approach that is kind of outside the box, and the partner's reaction at first was, including me, was, no, we shouldn't do that. But then we thought more about it and said we should, and the client has reacted very favorably to it. So, that sense of saying, in that case, look, you were absolutely right. Your idea is getting traction here, and that's great. That's exactly what we want. Want people to, feel. I often say, there's no point hiring smart people if you then put them in a situation in which they're afraid to contribute their very good ideas, right?
Yeah.
And that was a frustration of mine with my prior law firms, right?
And you still don't have billable hours.
We absolutely have billable hours, but we don't have
targets.
We don't have targets. We don't say you have to work this many, or I have always thought that having a target or a requirement even sends completely the wrong message. It sends the message that you will be gauged on how much you work, not on the quality of your work, and that. Again, in a professional services business, what matters is the quality of the work, right? And so we absolutely do not have, and as long as I have a say in the matter, we won't have targets or requirement.
Are you getting pushback for that?
No. I have clients, to the extent they think about these things. My experience has been that they don't like them precisely. If you have a target and you say somebody has to work 2,000 hours a year, nobody comes in at 1975 for the year, right? People will do the amount of work, push them over the target. And, clients are aware of that it's in essence saying, do work that might not be necessary because that's how we're assessing your performance. And, I don't think it's a huge thing with clients, but when they do focus on it, I think they always are. They never look at it with favor, right?
So how does that work actually on the client-facing side? How are you able to pitch a package if you don't know exactly how long it will take?
Well, yeah, I mean, I think we're reasonably good at estimating. Most clients these days, when you pitch something or and indeed when you have an ongoing matter, will want budgets. And once you have a case schedule, you can say, look, here's we're reasonably good at saying, here's what we think it's going to cost, month by month or quarter by quarter. And for some, to be clear, for some clients, we will do this on a fixed fee basis where we just say, here's a schedule of charges month by month over the trajectory of the case. And, we'll do whatever work is necessary. We'll, it may be more in any given month, it might be more or less, but we're pretty good at understanding, how much things are going to be, right? And so that's the primary tool, I would say, right? So we can have those kind of provisions in place with clients.
I had the privilege of visiting your firm and having lunch with your colleagues, and I was struck by how collegial the environment was. One common complaint, certainly in the post-pandemic world, but I think even before, was this idea that people weren't cohesive and weren't really interested in hanging out with each other. How do you foster the kind of environment at your firm?
Well, I mean, one of the things, and you joined us for this, that we had, and this was not my doing, it was my partner Jennifer's idea, and it's been a great idea, was to say, let's, one day a week, which by default is Wednesday, let's have lunch. Everybody, everyone who's at the firm, and people, if there's someone visiting like you, they're invited too, right? We just sit in a big room and have lunch together, and that has been a great, I would say at this point, I could call it a tradition already of the firm, right? That we do that. And it has been a very, very good thing. I think also my sense is that a lot of people were, the after effects of the pandemic is that people actually do want to be able to work jointly. And we have found so far, and I'm sure we're still benefiting from kind of the novelty of the new firm, but we have not found it necessary to set any kind of policy about you have to be in the office this many days a week, or which I know that many firms are doing, because we have people want to come in, right? And the general approach is, look, you're all professionals, you're all adults, I trust you get the work done. It has value to be physically in the office some portion of the time, but you decide when that will be, right? And we obviously have travel, a fair amount of travel. So we've not had any difficulty with motivating people to come in, right? And on any given day, typically about half the people are in the office, which is, it's been very good. And people, I think, enjoy being there. And, I see people using the common areas and things like that, right? That they want to hang out together and work together. And so for the moment, that seems to be happening organically without the need to do anything to help it along.
So, remarkable firm culture, no billable target hours, people want to hang out with each other, relatively flat hierarchy. Do you think this is a new model for practice?
I think I think people will experiment with different models. I think you can make other kinds of models work perfectly well, but I think it's healthy to have this kind of experimentation going on. And, if we're successful, then it will certainly send a message. I think to others, right? That it's ultimately, to me, it's all about inclusiveness, right? And having people feel like they belong. They are a part of something, not that they are just the hired help.
And in terms of lawyering in a post-pandemic world, what has changed, would you say, permanently or semi-permanently? We're not going back, whether it's dealing with the courts or dealing with clients or dealing with colleagues.
I think I think a few things have changed. I mean, of course, the idea of working remotely has had an enormous boost, and that affects a lot of our interactions with clients and with courts. I think that has it just pushed along a process that was already happening, and many courts would deal with fairly routine matters by phone. I think the widespread acceptance of video conference technology has really had to change things in a way that everyone realizes that there are certain things that still benefit from being done in person, but there's a whole lot that can be done perfectly well by video. And that would have taken, I think we saw a decade's worth of progress in a year because of the pandemic, right? Let's say. I think that the sense there is with it, though, a risk of people feeling like they are decoupled, or that we have a whole generation of younger lawyers in large firms who have never really sort of been in the crucible of the law firm, right? And particularly in certain kinds of practice, that's difficult. I mean, I think if you have a trial practice, people go to trial and they're necessarily working together under fairly intense conditions, and that's helpful. But there's a lot of practice that can easily become lonely. And, I think that's an issue for the profession that we have to kind of guard against, right? And I do think that there is, one of the lingering effects of the pandemic is a greater degree of what I would call alienation, that people just don't feel like they're part of something in the same way that traditionally they did.
One thing that one of your partners early, and I think when we spoke, you talked about it as being broader and almost a firm culture as social justice.
Yeah.
Talk about how that social justice manifests in your firm culture and what you do.
Well, it was certainly one of the founding principles of the firm was that the new law firm would have a commitment to social justice. And anyone who wanted to do work in that field would be encouraged and given the resources. And, it's not a requirement, but it is something where we would say, look, we've got, a number of sort of threads here. The unifying characteristic of which is we care about the world we live in, right? And Jennifer Wu, for example, has done a huge amount in combating anti-Asian hate. Eric Stone has done a lot in many areas, but right now has a case with the ACLU challenging the anti-trans law in Idaho. That we have in the level of both direct kind of legal action, but also involvement with organizations that are trying to increase access to justice. All of these things are part of the fiber of the law firm. I'm on the board of Legal Services of the Hudson Valley, for example, which basically brings legal services to underserved populations, hundreds of thousands of people who otherwise would not be represented in things like eviction proceedings and so on. And that is, these are all things that we look at and say, ultimately, it may be an old-fashioned view, but law is a profession, not just a job, and we have certain commitments to society. Lawyers are uniquely placed to be able to affect society and to stand up for people who need who otherwise who would suffer and whose position should be championed in some fashion. And so I think that just having a focus on that, was something we cared a lot about, and we want to make it clear that anyone who wants to be active in a cause like that is welcome to, but it's not, I wouldn't make it a requirement. I wouldn't say you have to do this, right? It's a personal choice, but it's one that is certainly encouraged.
Right. And another partnership I think that's been very significant, where you've shown lots of leadership, is with academia. And I've known you through the Fordham IP Conference. So talk about that connection with the Fordham IP Conference and how you think more lawyers can follow in your footsteps in establishing similar partnerships.
Well, I mean, you can't talk about the Fordham Conference without talking about Hugh Hansen. And, he did a phenomenal job of creating an institution. And I feel like I was lucky. Many years ago, sometime in the mid-90s, I went to my first Fordham conference, and somehow Hugh put me on a panel in a plenary session, even though I'd probably been a partner for 2 years at that time, something like that. And I had it was a wonderful experience for me, getting into a lively debate. That, I think, always, it left, that and other experiences early on left me with a great love of the conference and a desire to see it, be supported and to thrive. And I think, I don't think I'm by any means alone in that. I think one of the things that Hugh did very successfully was to create a kind of cadre of people, of supporters and partners for the conference. And I think that has been a great thing. It works because it has loyal supporters and participants. And in some fashion, that's precisely because people can go and actually have a real dialogue, and so I view myself as just one of many in that, but I do think that again, I view the patent world as an ecosystem, and one that has become a great deal more important over the last few decades as the economy has moved to be, innovation driven in a way much more than it was, say, 50 years ago. And it's important that we have dialogue and kind of self-assessment of how this ecosystem is working, right? You know, of how the policy is working. Ultimately, patents and intellectual property as a whole are just tools of economic policy. They exist to promote, economic advancement, and we need a robust dialogue around what works and what doesn't, and how we should change things. And academia plays a really important role in that. Right? Academics can bring a viewpoint that practitioners or clients, will never have, and can advocate views that otherwise don't have a natural constituency. And I think we need to have that engagement there. So I view it as a sort of fundamental part of the ecosystem. And it's, as a private practitioner, to the extent that I can be involved, be providing resources to encourage that, then I should. Right? And that it's healthy for all of us if that kind of debate and reflection is going on, right? And that academics are looking at issues and saying this is a problem, or or conversely, this is working well, right? In a way that it's no one else's job within the system to do that, and therefore we should encourage it, through tangible and intangible support.
And you mentioned Jennifer. It was good to see Jennifer there. So you're bringing folks from your firm. Do you think that forums like these need more partners and more champions like you to say, come join this? Or do you think the movement got its sufficient intrinsic appeal in itself?
I think it has quite a bit of intrinsic appeal, and I do think that one of the things that we're fortunate to have in the IP space is a lot of people who care about policy, right? They don't just care about how am I going to win this case that I have, right? And we seem to attract judges in a way that would be unusual in many other fields of law, right? Where they also care about what the law should be, right? And how the system should work. And of course, judges have some constraints in terms of their freedom to speak about these issues. But I have always been impressed with how the judiciary has been actively involved in the kind of the IP ecosystem. And so I think, we're fortunate that a lot of these things will happen more or less by themselves, but that one should never take that for granted. And I do think that it's important for lawyers in private practice to be actively engaged in encouraging things here. And I mean, it's not just through conferences, but as you mentioned, I've taught at law schools and things like that, that I think the viewing this as a sort of holistic approach to the field that in which we live and work is a healthy thing.
Yeah. So we want to switch gears
and
move to something other than what I talk about play. So you spend a fair amount of time on the racetrack.
I race cars. Yes, that is something that people sometimes comment on. Right.
Take us behind the wheel. And if you can, since this is a podcast on leadership skills, tell us how your time on the racetrack has shaped or refined your approach to leadership.
Well, I think one, I believe, I've reflected somewhat on why do I like doing this, and what I would say, one of the things about being in a race car is you have to focus completely in the here and now. You can't be thinking about that 30B6 deposition that you have next week. You're focused on how am I dealing with this turn coming up, right, at 100 miles an hour or something like that. So it pushes out all the noise that might otherwise be going on. And actually, you have, some people will say this, and it may sound trite, but there is a kind of Zen-like quality to it. It helps one focus, and I have found that to be useful in other things. I think it also there are some things in common with driving a race car and being a courtroom lawyer, which is, you have to be processing a lot of inputs very quickly in real time and making decisions, and not second guessing yourself about the decision that you made, right? Because you have to move on and focus on what's coming at you now. And so that, I think it's useful that, that there's a commonality there that has always appealed to me, in terms of training you to think quickly and to react to things quickly. But I think from a leadership standpoint, one of the things that anybody who teaches you how to drive on a race track will tell you, look further ahead, think further ahead. And the single biggest thing you could do to get better is think further ahead. And that, I think, is also it's a very apt metaphor for how, if you want to be an effective leader, think further ahead and look at how is all this going to play out, right? What's happening right now? How is it going to affect this person? And then how are they going to react to it, right? And
go ahead.
Yeah. Mm-hmm.
How old is the oldest person you've seen on a racetrack?
Well, I got out of the car in a race a few months ago, and I had been in very close quarters and close racing with another driver who was very good and had been, we'd been very mutually respectful. And he got out, and he was a lot older than I thought. And I didn't ask him because I thought that would be impolite, but he told me he's 78. And I was like super impressed. I was like, I should be so lucky to be able to do that at that age. And I believe that it's a well-known fact that Paul Newman became very enamored of racing and did it a lot. And he continued racing until I think he was 82 or 83. So
do you see yourself racing at 82 or 83?
I should be so lucky is how I would react to that. I'd like to, but you also have to recognize your limitations. So
what is it though about getting older when it comes to racing? Because physically, you're not sprinting or swimming. Where does the mental wear and tear come in, or the wear and tear?
It's very, very demanding. You have to concentrate in a way that you never concentrate normally, and be aware of lots and lots of things going on around you, and very small differences in your decision making and your inputs to the vehicle can have profound consequences. And so, if you turn the wheel just a bit too much that way, you may lose control of the car. And you ought to be thinking about these things all the time. And that level of what people will tell you at the end is they feel drained. And the degree of stamina that you need to be able to do that, for an hour, thinking that intensely, it's good training, but it's, age takes a toll on that. It just becomes difficult to do it.
Are you already feeling the difference, or not yet? Still having the best time of your life?
I'm absolutely conscious of that. There are times when I can say, I need to be really careful because I'm getting fatigued, and I know that that's a direct consequence of age. And I think just knowing one's limits is very important.
So, people might not have guessed from your accent or mine, but neither of us were born in this country. In fact, I would highly recommend our listeners to tune into what really is the first part of this interview that you did with Hugh Hansen, where you talk extensively about your adventures in Rio de Janeiro and the Amazon and how that led you to the United States. But you have been here long enough, I think, and yet still have had a foot outside of this country to be able to be reflective about American legal practice and IP law. So tell us a little bit about your reflections over the years on where we are with both.
I mean, like you, we are both immigrants, and for good and bad, right? And we bring with us a set of perspectives that hopefully can be useful to people, right? That when I started in this field in the 1980s, I was struck by a few things. One was, in some ways, how insular the legal profession was in the United States. It was massive. There were more lawyers here than perhaps all the other countries in the world put together, right? And law occupied a very important place in society in a way that's not unique to the US, but it's, I would say, relatively uncommon. There are many countries in which the position of the legal profession is much less important. But I sort of found it odd, that there was not more awareness of what was happening in other countries, and also the effects of history on the law here. There was almost, to me, it seemed as though there was a sense that what is now has always been, and that it's easier to understand kind of where we are if we look at how we got here. And in fact, for much of the history of this republic, there has been significant influence on its body of laws from other countries, and that I was surprised by how unaware many of my peers seemed about that. Now, I think that in some ways, particularly in the IP field, that has changed. And again, the very fact that we can have something like the Fordham International IP Conference is indicative of that. And I was also struck, as I learned more about patent law in particular, by how much the same it is around the world. We always focus on the differences, but the differences are really minor compared with the similarities, and that it makes sense for us to be, in some ways, sort of learning from one another because the similarities are so marked. And you really can draw meaningful conclusions from experiments that were conducted in other countries and so on. And so I felt like it in some ways was, I tried to play some small part in making people in the field more aware of what was going on in other countries, and building links to the profession in other countries.
When you see the decline of the British Empire,
yeah,
do you see parallels with what's going on now with this insular type of thinking and assuming that things will just go on as they were?
I think that there are parallels for sure. And I think that there's, in some ways, if a country is the dominant economic power in the world, it tends to lead to or encourage insular thinking, because you naturally have a sense of, well, this is the center of action, the center of gravity of the world. I don't really need to look at other things, and it can lead to a kind of complacency. I do think that kind of some of that happened. I think also that you had, there are a set of conditions in which the kind of things that tend to lead to isolationism in this country, that it was defined itself in opposition to the old world, to Europe, and people came here deliberately to get the historical view of the country's culture as we came here to leave things behind, and that can play into a worldview of which, why do we need to focus on that? But we're clearly going back. Have gone back to a certainly at least bipolar world, maybe tripolar, and I think the US needs to. It is nothing but a good thing to be cognizant of what's going on elsewhere, and to look at how other systems are dealing with things, and to understand that there's competition in the world, and you can't just take, this country enjoyed a long period of preeminence, you might say even hegemony, and you can't take that for granted. And that if it's correct, as I believe, and I think most people in this country believe, that competition is good, it encourages one to be better, to stay on one's toes, right? Then that I think is equally true at an international level, and people are well advised to, to focus on what's going on.
Even when you're the number one superpower that has to give way to the number two and number three.
But you might, it is, we could debate what it means to be the number one superpower, right? And, one way or another, China is, by any metric, has reached, or will reach parity. And also you have, at least economically, a pole in Europe, right? And so those things, I think, have to be, I think recent events have made the Europeans realize more that they need to be in charge of their own destiny in a way that, during the classic Cold War, they were not, right? And these are things that, we would all do well to pay attention to, including in our particular professional space.
Well said. So I noticed we're up against the hour.
Yeah.
Do you have another 5 minutes to wrap up?
I think I do. Hold on just a second. Let me check. Yes, I can. Another 5 minutes is fine.
Okay, we can do this in lightning round style.
Yeah. Mm-hmm.
Mentors and mentees. Talk about who your significant mentors and whether you're doing any significant mentoring at this point.
Well, I in terms of mentoring, I would like to, think so, right? But I mean, I to me, it's important more to create a culture where, say, I want everyone to be thinking in those terms, right? Now, I view in part my role at the moment as a significant part of it is creating space and creating opportunities for my colleagues to thrive. And, that's just, it's, being the oldest person in the enterprise, right? That's part of what I need to be focused on, is how do I create the best, help create the best set of conditions for my colleagues. But my own mentors, I had certainly had some along the way, but there was never any single person, I think, who was, the one I was looking up to. I would look, and it may have been, for better or worse, it may have been helpful that I was able to draw on, to take aspects of skills from various people and try them and say that works for me or it doesn't work for me and whatever. And so having a number of people that I could look to and say, you're an example, but you're not drowning out the other examples around me, turned out to be a good thing for me.
Okay. Second to last question. Amgen, talk about that in terms of your confidence in the Supreme Court's leadership in getting patent law right.
I think the Supreme Court has a difficult time with its role in the patent system, in part because, uniquely in the patent system, it has a rival, right? The Federal Circuit has national jurisdiction and sets patent law. And, that creates a different relationship from other areas of the law where the primary driver on the civil side, and indeed on the criminal side, often is circuit splits. So you can't have that. And you also have another court that is tasked with looking at what the law should be nationally and what the policy should be. And that, I think, leads to an unusual and at times awkward relationship between the two courts. And, the Supreme Court, of course, as it should, has a sense of, ultimately the buck stops with us. And if there's a problem, we're the ones who have to fix it. I think with Amgen, it's an example of a case that they took without really understanding what was going to be asked of them. And, it was illustrative to me that at the oral argument, you had justices saying, well, what is really in dispute here, right? And it's in some ways, it shows you how they are, how could we have got this far, with all of this, with a petition and then merits briefing and everybody weighing in, and now we're still saying, what is the case? Is the real?
What do you see from the 9-0 affirmance?
that I don't think they changed the law. I think they may have highlighted the law, but I don't think they really changed it. And for better or worse, and we can agree or disagree about what the law should be, but I think it that is an endorsement of the Federal Circuit, and the Federal Circuit, I'm sure, sees it as such. I think,
do you see? Go ahead.
No, I think you can juxtapose that with the situation in connection with Section 101, in which there is a very strong view in the patent community that something, the law needs to be harmonized or rationalized or changed in some fashion, and the Supreme Court has now, for the repeatedly now turned down requests to take further cases, including fairly plaintive calls from the Solicitor General on that, right?
Well, do you see that as an endorsement of the Federal Circuit?
I see it as them saying the law, it's complicated here. We don't really know what are the effects that, if we take a case, we don't know what the effects will be. And so when we took a series of cases, we changed the law in a way that evidently a lot of people are unhappy with. And we don't know how to fix that. And therefore, we need to we can't be in the business of taking cases and then being perceived to make things worse, because it will undermine confidence in the court. And so we're simply going to refuse to address this, and you all can try to work it out amongst yourselves. Right?
I'll take it and give the 9-0 affirmance.
Yeah, right.
Last question, 2023 and beyond, what should folks expect from Nick Groombridge?
I don't know. Well, trying to make the new law firm as successful as possible. I have a lot on my plate right now, and it's all great, but I'm going to keep doing what I'm doing, right? And having a great time, and hopefully, we'll continue to build our reputation.
And on behalf of all listeners, we wish you all the best in every of those endeavors, off and on the racetrack.
Great. Thank you very much, Daryl. That's great.
Thank you.
Thanks.